Hi, welcome to MediatorPodcast.com, a podcast and video series about mediation, negotiation, and collaboration. My name is Melissa Gregg, and I provide online valuation, divorce, and mediation services in St. Louis, Missouri. Today we'll discuss forensic psychology and mediation with Sherry Belitz. Sherry is an attorney as well as a trial, jury, and litigation consultant in New York. She also owns an educational company that teaches psychology to litigators. Welcome, Sherry. How are you?
I'm doing great. Nice to be here, Melissa. Thanks for having me.
Go ahead and give us some ideas of, attorneys will have a situation. And so kind of talk to us with attorneys and mediators, how they work with you. Is it for an entire case and you're doing a lot of the strategy just in general, or is it for specific? And it's probably for both, but maybe give us some examples of how people have utilized your services in a trial setting or a mediation.
Sure, that's a great question, and it's also one of my mantras because mock trials are one of the bigger services that I offer. And so many attorneys and so many people are under the impression, oh, a mock trial's a dry run. Let's do a mock trial pretty close to trial. But really, a mock trial it's a tool of leverage. I tell people, do your mock trial before your mediation, because then you're going to have an evaluation. You're going to either have a ton of leverage. You may want to bring that report if you do have a ton of leverage. And if things don't go the way that you think they're going to go, you're going to at least have a ton of knowledge and information. And you're going to be able to bring that to have a fruitful, productive mediation. So one way, and I'm not saying that there are not some dry run takeaways that you can get from a mock trial. But I look at a mock trial as a tool of evaluation. So I do mock trials. I do focus groups. Focus groups are usually done a little bit earlier. Sometimes they're even done pre-discovery. And that's really to kind of tease out the themes of a case and to really get some community attitudes and see what people think. Sometimes we'll put a video of something, of an accident or something in front of a group. Sometimes we will test out their feelings about a bunch of different categories that may come up in the case and things like that. I do a lot of preparation for depositions, which I think is the most important prep that you can do. Trial prep, obviously very important too, but you want to make sure your witnesses go on the record and they're an asset to your case and that they are increasing your leverage rather than having your leverage plummet. And the way to do that is to make sure they are prepared in their deposition. And depositions are often harder than trial for witnesses because depositions are cross-examination in a vacuum. There is no time, there is no room to tell that story, whereas at trial, you'll get a nice setup from your attorney in openings, in direct examination, perhaps some priming in voir dire to really set the scene before you undergo cross-examination, whereas deposition, you're just being crossed from that first minute and you're getting evaluated. So I think my most important work, other than those exercises, focus groups and mocks, are really the preparation of the witnesses.
I totally agree with you. And as we've been in this pandemic and even coming out of it, and we're having online depositions, we're having video depositions. I'm having video depositions recorded, even if I'm like, the plaintiff is recording it actively, proactively, right? And doing a formal deposition to at least have video testimony and to move cases along, which I kind of thought was a really brilliant idea. But as I've been kind of teaching other experts like how to even go about this new world, I think it is almost imperative. And I have been suggesting that, even if you've been doing this for 10 or 20 years, you need to go back to the prep go back to the practicing with the attorney, which we would do when we were all younger, right? When we were all like, I don't know, what are you doing? What are you doing? Well, let's practice. Like, I don't know, like, and our bosses wouldn't really know, like I remember the partners would be like, yeah, you guys go practice together or whatever. But now I think that this false sense of security that we had when we showed up at the courthouse and we knew, like there's a whole energy, there's a whole prep, there's a whole mentality, there's a focus, there's the adrenaline, right? Well, now I'm wearing my suit with tennis shoes, walking into my office, and I'm doing a Zoom. And the reality is it's not totally the right mindset, right? It's very different. And that's why you have, an expert that I was telling the story earlier, but an expert that starts to address the judge in an informal way, right? That is absolutely inappropriate and absolutely wouldn't have happened in court. And so I've been, saying, and I've even been encouraging my attorneys, like, let's practice a little bit. And they're like, you know what you're doing. And I was like, yeah, but when we layer in the technology, if we have a technology snafu, it then amps everybody up and they're focused on the technology when you need to be focused on like you're testifying, you're questioning, or we've had things where they ask a question and then the judge is like, I'm sorry, your video went out. Could you repeat that question? Or they say, can you repeat the question? Like, oh no, we just have somebody that's recording it, but nobody is actively dictating it. So we can't read back the question. I mean, everything under the sun. I had a computer crash in the middle of testimony. And so I think that the problem is we need to practice other things, right, during this time, because litigation and mediation is not the same anymore. And so you might know how to do what you do, but do you have the layer of complexity that's happening with hybrid situations, with video, with all of this that I think is different. So I think that you probably will see a lot more people doing the mock trials because you want to make sure everybody, like you're as good as your weakest link. So if I have this we had this situation where there was this brilliant guru and it was so awful because of the technology. And this person like wrote the book for certain issues in their field, right? I mean, they are the person. And yet the technology and the issues with that made them look not as great. So I think that if you continue in this space, working with somebody like you and using your services is going to be paramount to being successful going forward. And I don't know if you're seeing a lot of those technology issues, but.
I do think, and I think what's interesting is some of the tech is going to be here to stay. I think there's going to be a lot of virtual mediations. I mean, look, I think everyone is dying to get back in a courtroom to try cases and not have to deal with all of the problems with virtual trials. But I think there's going to be a lot of virtual depositions, a lot of virtual meetings, a lot of virtual mediations. And because this is a new medium and, used this way, there are things to learn and there are things to prepare. And I remember when I was actually a witness when I was working at a company and my testimony was going to be videotaped and I had to practice that was a lot different than giving testimony that was not videotaped. So I think anytime something switches up, practice. And early on in the pandemic, where there were still some cases being tried in person, I was actually talking to attorneys and I would give my clients advice about I'd say, you know what? You have to practice your summation in a mask. If you're going to be wearing a mask for, however many hours, everything you do, you practice in a mask. If your witness is testifying in a mask, you have to do that. If you're voir direing a socially distant jury, you better practice with that mask, have that stamina to be walking all over that courtroom, because that's a lot more tiring than what you're used to do. And no one in law school taught you how to practice practice during a pandemic, wearing a mask, voir dire a socially distant jury. So absolutely practice for new and exciting conditions. But I'm hoping we're coming out of that. But again, we're going to have some residual things that are going to remain hybrid or going to remain virtual.